sit up. All right, guys. What I'm going to do today is go through some slides that really very carefully and specifically point out what we've been talking about this semester today. To review, when I'm analyzing character evidence, the first question that I ask myself, is it other crimes, character, wrongs, or habits? In other words, does it fit into 404? And if it does, is character specifically at issue in the case? Now, why is that important? Because if character is specifically at issue in the case, the door is wide open, not only as to its admissibility, but also as to its form of admissibility. Because if character is specifically at issue in the case, I can ask both reputation and opinion and offer specific instances of conduct. Think the defamation claim in the Washington v. Hartwell case file, right? So I asked myself that. The next question, after I've gone through this thought process, on the left-hand side, and remember, that's the exception as opposed to the rule. It's very rarely where character is at issue in the case, and it's very clear, and I can just admit it all and let God sort it out. That happens very uncommonly. What most often happens, character is not specifically at issue in the case. But even though it's not specifically at issue in the case, I have ways to admit it. And we have talked the last couple of class periods about each of these. The pertinent character trait of the accused, the pertinent character trait of the victim, are other crimes, wrongs, and acts. There are three primary ways for us to make character admissible at trial when we are not dealing with a case where character is at issue, but where character is related in some fashion. Usually to do with whether it's more or less likely that someone did or did not commit the crime, was or was not the aggressor in a violent crime. And there are two primary tracks. One is where it's just the general character trait that is admitted, and the other is where it's some specific act, a prior bad act, that is going to be offered, not because it's a character trait, but because it proves what? Motive, intent, absence of mistake, knowledge. We're trying to argue that they knew what they were doing. What we think of as the exception under 404B. So, this means that when I'm in 404A, let me see here. Here we go. One more. So as I look at it, this is another way of thinking, right? Is evidence relating to character or other crimes or wrongs or habits, do I offer it? Yes. Specifically issue in the case? Yes. Admissible under 405B any form? No. I bring myself to 404. Now what's interesting, if it's not admissible under 404B, but is admissible under 404A, I'm limited in the form of how the evidence can be admitted. And we've talked about this in class a couple of times where we've talked about what? Reputation evidence and opinion evidence. And what I want to make certain tonight is that it's clear in your head how that is actually done so that you can properly do it. So we start with 404A1 and we ask ourselves, did the accused first offer evidence of their own character? In other words, did they open the door? If they did, then the prosecution can rebut. Now, as I think about this, there are a couple things that pop out in my head. That's the checklist. First offered by the accused. Only through reputation and opinion testimony. So if the accused is offering it, they can only offer it through reputation and opinion testimony. So when they open the door, although they control the key to the door, they are limited in the form of the evidence that they can offer. They cannot put in specific instances of conduct on direct examination. The first place that specific acts can be admitted is on cross-examination. And the reason is because the specific acts are offered on cross-examination to do what? To attack the validity of the reputation or opinion testimony. Because, as we'll see in just a moment, when I'm asking reputation or opinion testimony, there's some foundational questions that I have to ask in order to be able to admit it, right? Well, that may be a strong foundation or a weak foundation. And if it's a strong foundation, I ought to be able to check the validity of what you did or did not know when you came to that opinion. And that's why we can get into specific instances of conduct on cross. Now, when that occurs, there's something that I can do. Now, sometimes, though, character is not offered by the accused. The door is not open. And when the door is not opened by the accused, does that mean that propensity evidence, a pertinent character trait, is ever going to be admissible? The answer is no, under 404A. But there's always, in the back of our heads, the alternative theory of 404B. And the important thing that you just have to remember, I hope that you have developed the ability to read a fact pattern and identify motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or accident. Because those are all potential ways that a 404B character can be admitted. And what's interesting about this, I can have a pertinent character trait for being a drug dealer. The guy's a drug dealer. The state can never open the door to say, because he's sold drugs in the past, he's sold drugs this time. That would be a straight-up propensity argument, not allowed. But if I have specific instances of conduct from when he sold drugs in the past, and it lines up very closely with the current charged offense, it is transformed by the magic of the rule into the exception, where even though it is a specific incident of conduct that is arguably indicative of a character trait, it's not, for purposes of why it's being offered to the jury and which it can be placed. It's being offered to the jury under one of the exceptions. This argument between 404A and 404B is the heart of the character fight between the government and the state in almost every criminal defense case, where the defendant is not a first-time criminal who has never engaged in this sort of activity before. And it is the linchpin of which this sort of stuff tends to spin. Now, why is that important for us? It ought to be clear to you by now that wherever there is conflict and transformation for a policy reason within the federal rules of evidence, that's a place that is routinely tested on the bar exam, which means it will be routinely tested on my exam. And this issue of being able to differentiate between propensity evidence under 404A and a non-character theory of relevancy under 404B is one of those areas where we have made a policy decision that even though we won't admit propensity evidence, if the propensity evidence narrowly fits a non-propensity theory, we're going to let it in. And this evidence is so overwhelmingly powerful against the accused that the rule also requires notice to the defense and the provision of that information if you intend to use it as the prosecution. Why? Because we want the defense to be able to properly engage in the pretrial process to decide whether or not to plead the case out. Because it's one thing to have a conversation with the client who's never been suspected of a crime before. It's another thing entirely to have that conversation with the client when they've got priors or they've been suspected of criminal activity. And there's the rub. It's the one new thing that I want to talk to you about tonight. This is easy to do when I've got a prior crime that they've been convicted of, and I know the facts of the specific modus operandi of the prior crime. Because we're all comfortable with the fact that if a court's adjudicated it, we should be able to rely upon it in making this decision. Well, what happens when I've only got a prior allegation or a prior allegation that was or was not substantiated, but it was never adjudicated by a court? It was never looked at by a jury, and there was never any finality. It's an open case. Should I be allowed as the prosecution to admit evidence under a 404B theory of relevancy of prior misconduct when my proof of the prior misconduct does not rise to the level of an adjudication by the court? It's about as difficult as that particular issue gets. And what I'm going to give you tonight is the test to decide whether or not that actually works. And when I get to that, I'm literally pulling it out of the treatise that I gave you guys as supplemental reading. So don't feel like it's, oh my God, what's this? Now, character evidence of the victim works exactly the same way as character evidence of the accused, except for one particular difference. You know, it's got to be offered by the accused first. That's what opens the door. The same limitations on reputation and opinion on direct examination, specific instances on cross, and then specific instances on redirect, all directed toward the validity of the opinion or the reputation. And then when I don't have it, it's not coming in. But what's interesting is when it's the victim on the stand, and I can't use character evidence, a pertinent character trait relevant to the cause of action, I still have available to me all these other potential theories of impeachment. And this is a place where our theories of impeachment suddenly come into play. So I've got character traits that aren't pertinent to the cause of action, but may very well be pertinent to what? The truthfulness or the credibility of the witness. Because the victim is both the victim and the witness at the same time on the witness stand. So even if I go all the way through my and I come to the conclusion that I cannot admit a pertinent character trait, either because the door has not been opened or because the trait that they seek to offer is not relevant to the cause of action, I can always look at the things that we find right here. And these should all be familiar to you now. Character for truthfulness, prior convictions, motive or bias, prior inconsistent statement. They're all the methods of impeachment, and I run to those. Can't get through character. What's interesting, you know, from a law professor's perspective, is what happens when these two are arguably in the same universe, which is what we talked about in class last night when we talked about this intersection between 404 and 608 and 609. And you should have come away from that discussion last night with the clear implication that this is where the form of the question and the way in which the foundations for the type of evidence that I'm trying to lay matter significantly. So the questions that I do or do not ask, the moment where we are or are not in the process of the trial, are dispositive in trying to sort out which of these two categories I'm in. And the only way that you can do that sorting game is if you understand the doctrine underneath each of those particular theories of impeachment. It's why we break them out and teach them separately and have you play with them in your trial act class. Because we're wanting you to be able to make this connection between them so that you can choose how to apply it properly. So that's the way 404A1 and 404A2 work. I want to review with you for just a moment the way you prove it when you're actually proving it at trial. At the federal level, I have two means: reputation testimony or opinion testimony. Establish that it's a pertinent trait, but it's reputation or opinion, and that's it. Which means I must lay the appropriate foundation to satisfy not 404, but 405 in order to be able to admit the reputation or opinion. I can also get into it on cross-examination to test the validity of the reputation or opinion testimony that has just occurred. And it's in cross-examination that I can get into specific instances of conduct. Not to offer them up as character evidence, but to test whether the person who said X, Y, or Z about the person really knew what they were talking about. There's one other place, though. If I'm dealing with the entrapment defense, where they've raised entrapment as a defense, in other words, the cops tricked me into committing the crime, I come to the crime with clean hands, and but for the police officer inducing me to engage in criminal activity, I would have never done it. They've made it a character issue. Because one of the defenses to entrapment is what? That the person was predisposed to commit the criminal activity anyway. This is a connection between the substantive law and criminal law and the rules of evidence. So if I've got an entrapment defense, guess what? Specific instances of conduct are now admissible by the state during their case to rebut the entrapment defense. And they can put on evidence showing that the person does not have clean hands. And that door has been opened, it has been made relevant by the assertion of the affirmative defense of entrapment. That's why entrapment does not work for career criminals. Because career criminals always have a past. The moment they raise entrapment as a defense to what occurred, any other that they've engaged in the past with that sort of activity is now going to be admissible as a specific instance of conduct. And you should now see that connection between the entrapment defense and the way in the civil arena, when character is at issue in the case, character suddenly becomes part of the trial without the limitations of it only being a reputation or opinion testimony. So reputation testimony, how does that work? I've got some elements that I have to establish. This is in the trial ad book. It's in the materials, but I want to review it with you, so make certain that you've got it in your head. Member of the community of the person about which they're offering reputation testimony. Been a member for a substantial period of time. A substantial period of time is not defined in the rule, but it's sufficient amount of time to do what? To have knowledge of the reputation that exists within the community. That there is a reputation for a particular character trait, and the witness knows of that particular reputation. So it literally goes like this. Mr. Witness, how long have you been a member of Pelican Bay community? I've lived here for about 15 years. And in the time that you've lived in 15 years, what part of the state have you lived in? Well, I've lived over on Lullaby Lane. Do you know if Mr. Hightower, and I want to use, do you know if Brandy Alexander has a character for violence? Yes. I've laid the foundation for reputation. What is that reputation for violence? She's sweet as a church mouse, she's as violent, she's a crazy woman, whatever it happens to be. That's as much as I can do for reputation. Reputation, you will notice, does not have one element. There's a glaring element that is not up there from a foundational perspective. Personal knowledge. I have no requirement for personal knowledge when I'm laying reputation foundation. In fact, we don't care whether or not you know of the reputation personally, whether or not you've observed an instance personally. We just care whether or not you know of the reputation. And the idea is that if you reach the point where you have a reputation, it's so pervasive that the entire community knows about it, at that point it must be valid. That's the thought process behind it. Now, we, from a policy perspective, whether or not that's true anymore, and we could write a wonderful law review paper about the impact of social media on this, and whether or not you can now have multiple character traits, some of which exist for your digital self, and others of which exist in your personal or professional life separate from the digital world in which you live. But if any of you are trolls on the internet, I just do not want to know. Opinion reputation is slightly different, right? Opinion, you have to have personal knowledge of the victim or the accused. Rather than the relationship with the community that you require for reputation, with opinion, there's a connection and a knowledge of the victim or the witness individually. Then there has to be enough contact to form the opinion. Then there has to be an opinion, and then the witness states that opinion. You should remember that in the state of Florida, opinion testimony under 405 is not allowed. Florida does not admit or allow opinion testimony, only reputation testimony. But the federal system allows for what? Both. And I've told you before that if there are any Florida evidence questions, it's only going to be in these areas where what? Where there's a difference between the Florida and the federal system. And I'll tell you which set of rules to apply if I ask you about them. I point them out to you now so that we can learn them comparatively and so that they're in your mind, because evidence questions are ubiquitous on the Florida section of the Florida Bar. Not every time, but almost every time, there are about 25 or 30 multiple choice Florida evidence questions in the Florida part of the multiple choice. And they are generally known to be not very clear questions. So, that's different from proving character through cross-examination. When I'm on cross-examination, I'm trying to test the validity of the reputation or the opinion testimony that the witness has just given, right? And I want to show that the reputation or opinion testimony isn't valid. Now, one way that I can do that is with all the standard methodologies of impeachment that we've talked about earlier. For truthfulness, motive to lie, bias, prejudice, impeachment by prior inconsistent statement, whatever it might happen to be. Now, specific instances of conduct, on the other hand, are offered to test the validity of the opinion. So, for example, from my own past, I have a senior command sergeant major who has taken the stand to testify for the defense. And the soldier has presented a case where he says that I am a soldier of good character. And because I am a soldier of good character, it is unlikely that I committed this offense. There is a military character defense that's allowed under the military rules of evidence. Think of it as just one more pertinent character trait type of character. You've got the sergeant major on the stand, the kid's been in his unit for 3 years, and the sergeant major says, I know him, I've worked with him, I have an opinion as to his character as a soldier, and he's a damn fine soldier. This is the testimony. And I'm now the prosecutor to cross-examine the sergeant major. I've got specific instances of conduct that the soldier engaged in while in that unit. And I want to test the validity, the basis of the sergeant major's testimony. How might I go about that? Sergeant Major, I've got a few questions for you. How long have you been in the United States Army? 29. In that 29 years, do you believe like you have a good idea of what it takes to be a good soldier? Yes, sir, I do. Maybe when you've served that long, you will too. Thank you for that, Sergeant Major. Let's go over some things. Does a good soldier beat his wife? Does a good soldier put his wife in the hospital with bruises so badly that her eyes swell shut and she can't see them? Does a good soldier drink so much Crown Royal that he can't drive home? Leaves his children in the back seat of the car where he discovers them 8 hours later? Does a good soldier blah, 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 blah? Every single instance of conduct that I'm asking about, I have to have what? A good faith basis for the question. I'm stuck with the answer that the sergeant major gives me, and I focus on conduct of the person that they've given the reputation or opinion testimony in support of, right? Hang on just a second, I'll get to it. I can't ask a guilt-assuming question. Does a good soldier stop beating his wife? Because that implies what? That he's been beating his wife. But if I have specific instances of conduct, I can ask those questions. I'll ask those questions in the hypothetical. And then I'll go, Sergeant Major, were you aware that the defendant received Article 15 punishment for beating his wife? Were you aware that the defendant was picked up by DUI? Ask all those questions. Now I'm doing what? Challenging the basis of the sergeant major's knowledge as he formed the relevant opinion. And after I've given the hypotheticals, confronted him with the reality of what the defendant has previously done, I then ask the question that I don't care what the answer is. Sergeant Major, knowing all of this now, do you still testify under oath that he was a damn fine soldier? Well, sir, he was when I was around him. Exactly. And you only saw him at work, right? You never saw him in personal life. No, I didn't. But you would agree that a soldier is a soldier 24/7. hours a day, 7 days a week. So it's possible there's a lot that you just don't know about this young man, isn't there? I'm done. And so is the defendant. Because what have I just got to do? I've gotten to go into all those specific incidents of conduct that had previously been kept out of the trial because they were not admissible under a 404A theory of relevancy, and they weren't admissible under a 404B theory of relevancy because they didn't fit the crime in question, which in that particular instance happened to be a drug deal. And all these other crimes were violent. But because they were dumb enough to put the sergeant major on the stand and say he was a damn fine soldier, they opened the door nice and wide for me to cross-examine, not to offer the evidence substantively, to say that the defendant did these things, but instead to attack the validity of the sergeant major's opinion. Now you ought to be thinking to yourself, man, if that was my client and I had done that, what would I do? I would start objecting to the admissibility of those questions anyway, trying to shut it down and arguing that the prosecution was doing what? Trying to smuggle in impermissible character evidence. If I'm the prosecutor, what would I probably do before I began that cross-examination run? Your Honor, may we have a sidebar? Your Honor, they've just opened the door to specific instances of conduct as it's relevant to test the validity of this opinion testimony. The government has a good faith basis to ask the following questions. Boom, 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 boom. It is my intention to inquire into those now. I want to give court and opposing counsel notice so that we can deal with any objections before I start. Now, you do that, in all likelihood, there's going to be a recess. The jury's going to go out, and we're going to have a little discussion about the law. And I'm going to win because the defense counsel opened. And it's really not my problem whether or not he's going to have or she is going to have an ethical complaint lodged against them for ineffective assistance of counsel. Because they opened that door. Over here first and then here, because you had your hand up first. Did I answer my I thought I probably would. That's why I wanted to keep talking. Go ahead.
I have two questions. The first one is the specific instances of conduct that are allowed. Is that just asking the question, would a soldier beat his wife, or can you then also ask a question like, did the defendant beat his wife?
Not did the defendant beat his wife. I could ask this question. Sergeant Major, were you aware that the defendant, by his own admission, hit his wife so badly that he had to take her to the hospital? I am bound by having a good faith basis for the question, and I have to look at what information I have to fashion those questions so that they're appropriate. And I'm also bound by the breadth of the character trait that they've just given an opinion on. And the broader the character trait, the more things I can get into in response. The more narrow the character trait, the more narrow the slot is. So, for example, let's say the character trait is for honesty in a fraudulent case, and they've very narrowly said, "What is your opinion of this individual as it relates to honest dealings in business?" That's a pretty narrow opinion, right? Could I get into any spousal abuse to test the validity of that opinion? No. So it means you've got to look at the nature of the opinion, the breadth of the opinion, and the type of specific instances that you have a good faith basis to ask. Here's the beautiful thing about it. I don't have to prove any of this good faith of these questions. There's no inquiry as to whether or not I've truly got enough evidence to ask. I merely need a good faith basis. And it's why when I begin my case investigation with these sorts of criminal cases, I cast that net broadly. It's why I need to know the priors. It's why I need to understand the person in the community, because it's going to give me the tools to deal with reputation and opinion testimony when it comes up. So it will be very, very helpful to me. And then you had a second question.
Yeah, it should be pretty quick. Where it says you're bound by the answer that the witness gives.
Yes.
Can you, if you have, say, a prior inconsistent statement?
Well, if it's a prior inconsistent statement, yeah, but what I'm really focusing on here are specific instances of conduct for which there may be extrinsic evidence. But because this is only being offered to test the validity of the opinion, it is at a certain level a collateral matter. Just like when I ask the person about things that they've done that were untruthful under 608, I'm bound by the answer. Because otherwise we would get way off track and we know personality in the trial.
I have a question about character evidence in a civil trial.
Mm-hmm.
and that is, if you have let's say an intentional tort case, and the defendant is claiming self-defense, for example, does that put character at issue?
Is self-defense one of the big ones that I mentioned to you out of the case law? No, it's not. So you would need to find a case in the jurisdiction that makes that argument or try to make it. Now, I would argue that a character for violence might be relevant in a self-defense case, but you'd have to find something in the jurisdiction that had applied it. And you're going to have a hard time doing that in the Florida court because Florida is phenomenally narrow in the way in which they'll let that 404B stuff come in. We've got case law that says the prior conduct almost has to be exactly on point with the current charged offense before it comes in. It's very on 404B. Now, of course, 404A is broader because that's controlled by the defense, and if they're dumb enough to do something, then they get what they deserve. Yes?
If you have employment, if you're dealing with employment type stuff, I was trying to think of, like, you gave us a great example.
Negligent hiring is the example in employment where potentially character is at issue. Negligent hiring. But not just general employment behavior. Even though it might be relevant, they're on the door to character.
I see. So you can't say, would a bad employee or would a good employee do this bad thing or do this bad thing or do this bad thing? Were you aware that your employee was doing this?
Yeah,
or
but
vice versa?
But if it's an employment action, let's say for wrongful termination, you're never going to let them come in and give opinion on whether or not they were a good employee because that's giving opinion on the ultimate. An expert opinion is not helpful.
So like a manager's call to say that this person was a bad employee and this is the reason they got fired. In cross-examination when you're representing the employee.
Well, if they said that if that's the reason,
right.
then you could attack the validity of that reason.
So in essence, would you do would it almost be the opposite of this? It would be like.
Okay, I'm going to stop this inquiry because I feel like we're walking down the path of a 4-hour trial.
Sorry.
And I'm not going to walk any further
Not
down.
mine, but I
No, it's okay. You don't need to apologize for it. It's just that the answer is make certain that you're in the right lane when you're looking. Okay? Don't try to put a square peg into a round hole. It's not always a character evidence issue. Sometimes it's another issue, and that's where you can get in trouble with. All right, let's look at 404B to go over it again. And I've got a flow chart for it as well, right? Was the evidence offered to show that the accused acted in conformity therewith? And remember, conformity therewith is another way of saying what? Propensity evidence, right? If it was, it's not under 404B, but it would be admissible under 413 or 414. And it's also potentially admissible to meet the constitutional requirements of 412. Think of the State v. Lewis case file. The whole reason that I've got that case file in there is so that you understand that sometimes character traits or sexual conduct can be made relevant under the 412 standard. And it's written to create that issue. Most of the time, it's not being offered for propensity, it's being offered for the others. Motive, intent, preparation, plan, knowledge, identity, absence of mistake or accident. The classic 404B ones. And if that's the reason, hey, I'm good to go. It always raises a 403 consideration. And because it always raises a 403 consideration, sometimes I'm going to have low probative value and a high risk of prejudice. And in those instances where I have low probative value and a high risk of prejudice, unfair prejudice, even though it meets one of the non-exhaustive criteria under 404B, we're going to keep it out anyway. How should you think about low probative value? Well, the less similar the uncharged misconduct, the other bad acts are, to the current case, the more differences there are, the lower its probative value. Now, the more similar they are, the greater its probative value. But also the potential for prejudice creeps up. But then the question becomes, is the prejudice fair or unfair? Because all evidence is prejudicial or it's not relevant, right? That's where the game is when I'm dealing with 404B stuff. And this is the flow chart. This is the way we look at it. But what the flow chart does not show you, and what the rule doesn't really explain, is the burden of proof to establish the admissibility of prior wrongs or bad. Right? What's the burden of proof? You know, how much do I have to offer to get it in? And I really have to go and look at the, oops, I hit the wrong button there, hang on. I have to go and look at case law and the notes. And what I find, look at case law and the advisory committee notes, is that there actually exists a 4-pronged test that you use to convince the judge that the prior acts are admissible, that they are reliable enough that we're going to let them in under a 404B theory of relevancy. So what do I look at? I look at the purpose behind offering this evidence to the jury. I consider the relevancy protections of 104B. In other words, has the judge gone through their 104B analysis to determine whether or not the evidence should be admitted to the jury? And that's the gatekeeping function of the judge. It's the judge's responsibility to do it. And if I'm the proponent of the evidence, I use the standards in 104 to show the judge how this evidence is admissible. And so I bring in otherwise admissible hearsay to buttress my argument that this 404B stuff should be admitted because we can rely upon it. And maybe that inadmissible hearsay happens to be a sworn statement from one of the alleged victims in the prior case that didn't go to trial for some reason, where the facts as described by the prior victim are remarkably similar to the facts that happened in the current case. I can do that because 104 in the federal system would allow me to do that. 104 in the Florida system would not, right? Because it's got to be otherwise admissible evidence in Florida. And then I look at the balancing test of 403, and then I apply the limiting instructions of 105. So if I identify with specificity the purpose, whether it's motive, intent, absence of mistake, opportunity, whatever it happens to be, I tie my argument to one of the specific factors in 404B. I then show the judge how I have evidence that the judge can look at that supports the existence of this prior act that the judge is allowed to consider under 104. And then I ask the judge to apply a 403 balancing test. And as the judge wavers or waffles on the 403 balancing test, I remind the court, and I might even ask sua sponte, of course, Your Honor, we would request that a proper limiting instruction under 104 be given so that the jury does not inadvertently misapply this evidence for an improper character purpose. Now, you ought to be thinking, that's evil. Because what I'm really doing from a persuasion perspective is underlying the facts in question when that limiting instruction is being given. There's nothing that prohibits that. We presume that the jury is going to follow the instructions of the judge, and if I get some persuasive value out of it as the proponent of the evidence, good for me. Yes?
You oftentimes talk about asking the judge to give a limiting instruction. As the opposing counsel, can you just, if the judge already makes his ruling, we're going to allow this in, and then he says, you know, Your Honor, we can ask for a limiting instruction, can you just say, it's okay,
Yeah, you can waive it, but at this point you've now waived the issue, so I don't have the appellate question either way. If you waive the limiting instruction, you have basically at a certain level either admitted that you think it's okay, or you have, as a practical decision, decided to forego the potential appellate issue. So how, as opposing counsel, might I address that? Your Honor, we do not agree with opposing counsel that a limiting instruction will cure the unfair prejudice of this sort of evidence being heard. It's our position that giving a limiting instruction will not limit anything because of the reasons that we've already outlined in our argument. I don't say I don't want the limiting instruction. I don't say I do want the limiting instruction. I go back to my earlier argument and tie it to the limiting instruction, because I'm trying not to waive it. And if push comes to shove, well, then I may or may not request that limiting instruction. Now, here's the interesting thing in the federal system. The judge's instructions on limited uses for which evidence can be given when the evidence is admitted, or at the end of trial when the jury is charged with the instructions. The federal judge has the ability to slide one way or the other and control their courtroom. A Florida judge does not. A Florida judge is supposed to give the limiting instruction at the moment when the evidence is heard by the jury. The thought being that if I don't do it when the jury's heard it, they're not going to be able to sort it out later, particularly in a longer trial. I personally think that the Florida rule makes more sense, but it also places the duty on the judge in those instances where limiting instruction would be appropriate to give it sua sponte. Even
Sorry, I come in like that so you don't hear clack.
I don't care. The clack doesn't bother me. She just looked like she was creeping around. Like she's going to get somebody. I thought she was going to go over here and say boo. Or that was awesome. I wish I had a camera on it. It's like something I said in that live. That was great. Oh, that's funny. But when we think about that limiting instruction, this is something we've talked about multiple times, or at least I've talked about it and you've been forced to listen to it. Why? Because it's interesting, right? This is a power that the judge has, a requirement for something that the judge must do, that has an awful lot of unintended consequences from a persuasion perspective. And then we have to make some hard decisions as the advocates of whether or not we want that instruction to actually be heard in court. And one of the nice things about it in the federal system is I don't need the judge doesn't have to give the limiting instruction now, and I might let it just sort of flow through the rest of the trial. And then when we have our conference before instructions are done, I'll just say, well, Your Honor, we've decided to waive the need for the limiting instruction on those issues. Because I made a determination based upon the rest of the trial that it ain't going to matter. Or that I don't want the jury reminded of that evidence. And I'm in a better place tactically to make that decision at the end. Whereas if I have to make that decision, I might jump the wrong way. It was why, as a prosecutor, because the limiting instruction doesn't hurt me, because I've won on getting the evidence in, and I don't ever intend to use it for an improper purpose, I like to have it highlighted, underlined, and an exclamation point put on it before we move on to the next topic. Because when the judge stops the trial, persuasively, the judge stops, the judge opens the book of instructions and reads to the jury from the book of instructions. That's like that's a change in who's talking, who's speaking, and they're doing it because I've asked them to. So from a persuasion perspective, what does that do? The prosecutor asks for something and the judge does it. The prosecutor knows what they're doing. The judge is validating, even though they don't intend to, and that's not the purpose of it. But to a juror member, you can make the argument that that's happening. It's why, and we don't talk about it very much in the evidence class, the true practice of law, whenever you're actually preparing a case for trial, is spent more in the instructions that are available in the jurisdiction than anywhere else. Because those pattern instructions are a representation of what the local bar culture thinks the law should be as it is applied in a common sense language. And if you know that the court is going to use language out of instructions as part of their charging of the jury, and you can wrap your theme and theory of your case around those instructions, you start to sound more like the judge. And that's usually a good thing from a persuasion perspective. But that's something that if you take advanced criminal trial advocacy, for example, here you'll talk about it. We talk about it in some of our damages cases and other places. Now, proper purpose, it's got to be probative of a material issue other than character. And when I say probative of a material issue other than character, what do I mean? I mean that it fits into a comparison between the prior conduct and the current charged offense. It's really what it means. And it's nothing more than a 402, 403 analysis. And the court's just looking to see, is there some proof that this act happened before? And does it actually connect? Now, what's cool about this? Under 104, if the court finds that the jury could find the conditional fact by a preponderance of the evidence. So they look at the evidence that you have to say that the prior act occurred, and the judge goes, well, if a jury was to hear this, and it doesn't even have to be the jury at trial, just a jury, if a notional jury heard this evidence, would they think it was more likely than not that it occurred? That's enough to lay the foundation. And if you think about it, that's a relatively low standard. It's 50.1%, right? Kind of cool. The balancing test of 403 we don't need to talk about. It's the same balancing test as always. And then of course 105, I've already beat the drum on 105. So this is the last slide that I want to share with you tonight. And then thanks to your classmate Jason Isbell in the 400 unit, you will be released. Finally, someone stepped up to the plate and displayed some knowledge of appropriate music. And of course, it was a woman. I'm not even surprised. I'm not even surprised. All right. We start on direct examination with the testimony of a witness. And the first thing we do is we lay some background information about the connection of the witness to the defendant or the victim. And once we establish that background information through certain facts that we ask, we've now laid the foundation for what? For the reputation or opinion testimony. Now, in the laying of the foundation, in the addressing of the background information and the facts that support it, there is an advocacy opportunity to push the envelope of specific instances without getting into them. So it might be, do you know the accused? Yes. How long have you known the accused? I've known the accused for the last 3 years. In what capacity do you know the accused? I work with him. How many days a week have you spent with the accused at work? Well, 5 days a week. In an average work day, how many hours did the accused? Well, I probably see him about 6 hours a day. So you see the accused about 30 hours a week? Yes. And you've seen him 30 hours a week for the last 3 years? Yes, I have. Well, in all that time, have you had an opportunity to form an opinion as to the accused and then insert the pertinent character trait, right? You see how laying the right foundation is buttressing appropriately the validity of the opinion testimony. I didn't get into specific facts of what he saw the accused do that's connected to the character trait in question, but I've really fleshed out how much time he spent with them. And if you go and look in the examples that are in the practice commentary portion of evidence practice under the rules, you'll see this sort of application, pushing the envelope of laying the foundation appropriately. Now we get to cross-examination. And when we get to cross-examination, this is where we get to have fun. We get to ask those specific instances on cross-examination to attack the validity of the opinion testimony that's just been given. And it is only after that, when we get to redirect, that we now allow the witness to explain the specific instances relied upon when they initially formed their opinion as to the pertinent character trait. And in both instances, both here and here, the only reason that those specific instances of conduct are admissible is to test the validity of the opinion. And that's it. Now that, in a 40 minutes, maybe a little bit less, is about as concise an explanation of 404A, 404B, its connection to 405 and to 104 and to 105 as you can possibly find.